We're looking at the latest Supreme Court decision. We're tracking it all the way from the court below, the district court level, the Court of Appeal, and then the Supreme Court. And then we'll look at some trending news if time permits us. So join in if you can hear me well and see me great. Please type USA or put in the emoji of the US flag. If you can see me and hear me great, that will be our signal to get started today. We have a lot of exciting discussions. I'm going to be showing you guys hidden legal insights that you need to see about discussions that are going on in US immigration. The way things are moving at such a fast pace, many of the discussions remain at a very superficial level because we don't even finish discussing one thing and then the Trump administration hits us with the next and then the next and then the next. So sometimes we need to dive into some hidden legal gems so that you can see what's actually going on. Okay. Deep Carora says dark chocolate. Okay, on Instagram. Okay. Yes, I see some US flags on Instagram. I don't see any US flags or USA on YouTube, LinkedIn, Facebook, TikTok. Please drop those emojis, drop the emojis, and then we can just get started. Once we get about 10 of them across platforms, at least from Facebook, LinkedIn, if you're watching from there, please, if you can hear us, please drop it so that I can be sure. Otherwise, that means there's an issue with the sound and you cannot hear me. All right, I see something from Facebook, and I see something from TikTok. I'm not seeing any USA typed in. USA, just type in USA so we can just get started. Okay, guys. We are going to be sharing my screen as usual. I've highlighted a bunch of things I want to discuss with you. So yes, drop your questions. We'll be answering them very soon to see how we can assist you. Okay. All right, let's jump into it. All right. So the latest Supreme Court decision, immigration related, that is causing a lot of concern or worry to many people. Now, the actual decision that started this whole thing was given by a Ghanaian woman called Mame Wusi Mensah Prempong. She's a district judge for the Central District of California. So the case went up to, well, maybe I should go back. Let's get started with that. There were raids that they called roving raids in California, and specifically in Los Angeles, I should say. This was specifically in Los Angeles. ICE was going around using aggressive tactics. They raided Ventura farms, farms, car washes, markets, bus stops, construction work sites, landscaping places, just a whole list of places that ICE was raiding. And they would get there and use aggressive tactics. Once you looked Latino or you did not look American, then they would accost you and ask you, "Are you American?" So from the actual case, Judge Mami Ewusi Mensah, I believe, talked about the fact that there were some people that were accosted and they were questioned. Are you an American citizen? And they would say, yes, I'm an American citizen. They would say, show me your ID. Another person, they would ask, well, what hospital were you? The person was like, oh, I was born in the US. And then this Latino man, he says he was born in the US. He asked, what hospital were you born in? And he does not know the hospital he was born in. Many of us may not know the hospitals we were born in. So he couldn't tell them the hospital he was born in, and ICE took his ID and took him to some other place and tried to verify his citizenship status. There were a number of these raids, very aggressive, and they were picking people up merely by how they looked, whether they spoke. So if you were found speaking Spanish or you were found speaking accented English, like mine right now, ICE would approach me and interrogate me about my immigration status as to whether I am required or allowed to be lawfully in the United States. Accented English, speaking English with an accent. So you looked if you just looked like an immigrant, then they would come and then start questioning you. Under the U.S. law or under U.S. laws, the Fourth Amendment says that we are protected against unreasonable searches and seizures. And so case law has time and time again stated that in order for, in this context, immigration officers to question you, they first of all must have reasonable suspicion. This is to avoid what we call racial profiling or just targeting people based on their skin color, which the US Constitution doesn't allow. The officer has to have something called reasonable suspicion that you are here in the US unlawfully. And so there were all these raids going on in Los Angeles, and the plaintiffs challenged ICE practices. And then they took it to this district court in California, and Judge Mame Ewusi Mensah Frimpong, she issued a temporary restraining order, TRO. She blocked ICE from stopping and questioning people in Los Angeles based on only 4 factors, either the factors standing alone or a combination of these factors. Number 1, based on apparent race or ethnicity, speaking Spanish or accented English, being at certain locations. And the locations would be where immigrants typically gather to look for work or get picked up for quick work, okay, day work, labor sites, farms, car washes, or having a type of low wage job where you are not paid that much. That's how ICE was targeting the people. And in the decision, the judge mentioned that ICE had been given quotas of about 3,000 arrests, a day, and they had to use some of these tactics to be able to ramp up their numbers or get up their numbers. Okay, I'll be referring to 3 decisions during this live session, and so some of the stories are across, right? Because Mame Ewusi's judgment decision alone was about 51 pages. The Court of Appeal decision is about 61 pages, and the the Supreme Court decision is about 31 pages, all in the case of Noem versus Vasquez Pedro Perdomo. That's the case we're looking at. Okay, obviously, when there's an appeal, sometimes it can the name changes. It can become Pedro versus Noem. I'll confirm all of that. So it's across these 3 levels. So bear with me. Okay, now let's go on. So the Judge Ewusi said, "Look, ICE, you are stopped. You have been issued with a temporary restraining order. You cannot use those factors alone, even together, to unlawfully profile people, because this is not allowed by the Fourth Amendment. This is not allowed by the Fourth Amendment of the US Constitution." So let me go into the Court of Appeal decision. It summarizes everything really nicely, so we can use that for our purposes. This is where the case was appealed. I'm not sure. Yes, I think you guys can see it real good. Okay, so I'm sorry. No, this is the Supreme Court decision. Let's go here. All right, let's come here now. Let me make sure you can see what I can see. Yes, you can absolutely see what I can see here. All right. So the district court granted the plaintiff's motion for a temporary restraining order prohibiting federal officials from conducting detective stops for the purposes of immigration enforcement without first establishing individualized, reasonable suspicion that the person to be stopped was unlawfully in the United States. So they are not the ICE was not permitted to rely solely alone or in combination on the factors to form reasonable suspicion for a detentive stop. Apparent race or ethnicity, speaking Spanish or speaking English with an accent, presence at a particular location, the type of work one does. You see what the Court of Appeal did? They wrote speaking English with an accent. It was supposed to be an N. Everybody makes mistakes, even the courts, right? So yeah. So don't hurt yourself too hard when you make a mistake. It's part of life. The panel held that it had jurisdiction to consider a motion for stay of a TRO pending appeal. Okay, let's go to the portions I'm looking for. I'm going to go directly into I believe I had a copy of the TRO. I think it's on page 25. Let me see if I can just pull that up because we don't have time. So I just highlighted a couple of portions I wanted to show you guys. Let me just jump here. Okay, there you go. So the temporary restraining order by the judge, Mami Usi, the Court of Appeal affirmed it and said, this is fine. I'm not granting the Trump administration a stay on the block that they have not to conduct these roving patrols. So the TRO said, as required by the Fourth Amendment of the US Constitution, defendants shall be enjoined or stopped from conducting detective stops in this district unless the agent or officer has reasonable suspicion that the person to be stopped is within the US in violation of US immigration laws. Now, you guys, reasonable suspicion means just that. The suspicion has to be reasonable. If you are stopping somebody thinking that they are here in the US unlawfully because they are black, that's an unreasonable suspicion. It's very unreasonable because there are people who are here who may have the color of my skin, who are US citizens or could be green card holders or could be here on valid status or some type of, they are in lawful status. Or somebody can be speaking English, accented English, but they're still here lawfully. And so it's unreasonable. And so what the judge at the district court level, Mami Usi, did was that she was saying, don't use these factors because you have to have more than that. It has to be individualized, particularized, reasonable suspicion that the person is unlawful. So pretty much the district court, the Court of Appeals, right? Because the Trump administration was not happy with the temporary restraining order that had been placed on their ability to conduct these stops based on these four factors. They took it up to the Court of Appeal. Court of Appeal said, I agree with Mami Wusi. Let's move on. The Court of Appeal only took out this part, except as permitted by law, out of the TRO. Because the temporary restraining order included this part that said, except as permitted by law. And pretty much the judge was saying, I am granting the stay as to this part, meaning that part was confusing because it's as if the district judge was saying, except permitted by law. So if the law allows you, you can use apparent race, ethnicity. But the district court said no, the Court of Appeal said no, let's even stay that part as well. So the TRO was left intact, but this part, except as permitted by law, was stayed. Okay, so the law doesn't permit it. End of story, period. The law does not permit you to, use the skin color or accent to stop somebody and start questioning them based on the fact that you think they are unlawfully in the United States. Okay, let's just move on to the Court of Appeal. I'm sorry, the Supreme Court now. Okay, well, once the Court of Appeal said we agree with Mami Usi, we disagree with the Trump administration. Obviously, the Trump administration was not happy, and they moved on to the Supreme Court. Okay, so now let me share the Supreme Court, and I'm going to tell you how this works. So this. Oh my gosh, this went off. Let's pull it back here. I think this is it. Excellent. So look at what happened here. In this case, the application for stay, this was by, no, this is not it. Oh my gosh, guys, forgive me. I just have so many case laws pulled up. So I need to get the correct one for our purposes. I got the wrong one. It must be this one. I'm going to tell you what happened here. So the Trump administration actually asked Justice Keegan, who is the circuit justice for the Ninth Circuit, to block that lower court order, and she referred it to the Supreme Court. Justice Keegan is one of the justices on the U.S. Supreme Court. Now, each Supreme Court justice is assigned to one or more federal judicial circuits based on geographic regions. So, Justice Keegan, for example, is for the Ninth Circuit. When emergency applications like this one, which is a stay or an injunction, comes from that circuit, they directed this one to the circuit justice, which was Keegan, and Keegan could act alone by looking at it and granting or denying the application. But she decided to refer it to the full Supreme Court because she probably felt like the issue was a significant one. She didn't want to act alone. Okay, I'm still trying to pull up the Supreme Court decision here. Let me see why this isn't working. Let me just take this off. Let's try again. Guys, bear with me. Not this one. It's actually this one. Okay. Okay, so this was Cristinoem versus Pedro Vasquez Perdomo. Nice rhythmic name. Let me share the screen here. Okay, I think it works now. All right, so as I was telling you, the application was sent to Justice Keegan, who's the circuit's justice, and she decided to refer to the full panel of the Supreme Court. And the Supreme Court issued the interim action, which is an interim order, right? They didn't hear arguments, and there wasn't a full briefing, and there was no amicus curia. It wasn't a full Supreme Court hearing. It was just an interim order, right? So now Justice Kavanaugh is the one, I believe, who gave the majority decision, and Justice Kavanaugh made some really interesting comments and pretty much said that, look, he's granting the stay of that TRO because according to him, those factors form what we call reasonable suspicion. So they should continue with the good work they are doing. Justice Kavanaugh mentioned that there's at least 15 million people who are undocumented in the United States, and he said that they make brief stops to the ICE or the government. They make brief investigative stops to check people who gather in locations where people are hired for day jobs or who work or appear to work in such jobs such as construction, landscaping, agriculture, car washes. Those type of jobs often do not require paperwork, right? Because many of those jobs you may not necessarily need a work permit or a green card or US citizenship, and they're attractive to illegal immigrants and who do not speak much, if any, English. This is all said by Justice Kavanaugh, a Supreme Court justice. And so, okay, let's move on. There are a couple of interesting, yeah. So he mentioned that this was fine. The government must have reasonable suspicion, and he talked about the fact that reasonable suspicion is a lesser requirement than probable cause, which is a higher requirement, and then it's short of preponderance of the evidence standard. He clarified, Justice Kavanaugh clarified that apparent race or ethnicity alone is not reasonable suspicion for ICE to stop you, but it can be a relevant factor, meaning they'll look at your skin plus other things, along with other salient factors, and that can be reason for ICE to stop you. I hope you guys can see my screen. We're not making this up. This is all from the Supreme Court decision. And as always, I want you guys to see it from yourselves. From the color of the law, you can see it very well. Okay, so now that is what this means. This was a 6-3 decision by the Supreme Court, and they're saying that these factors, the color of your skin, if you speak English with an accent, you work a low wage job, or where you are found, you can be stopped by ICE, because that a lot, those factors are relevant to determine whether a person is lawfully or unlawfully in the United States. And I just want to go back to the 4 factors alone so that we can have it directly from the Supreme Court. Okay, this is what the Supreme Court said. The Supreme Court said that the first factor is, okay, yeah, the presence at particular locations such as bus stops, car washes, day labor pickup sites, agricultural sites, and the like. Number 2, the type of work one does. Number 3, speaking Spanish or speaking English with an accent. Number 4, your apparent race or ethnicity. Let me go to a certain portion of what Justice Kavanaugh mentioned, which you guys might find interesting here. He said that, okay, I like not this part though, but this part was another interesting part where Justice Kavanaugh said that, when you're trying to decide on whether a stay is warranted, there's a balancing act. They want to balance the harms and the equities. They want to see, is there going to be harm caused to the government if they don't grant the government the stay. And he said, in those circumstances, to borrow Justice Scalia's apt words from a different context, trying to determine whether one party's harms or equities outweigh another party's can be akin to judging whether a particular line is longer than a particular rock is heavy. So kind of they want to balance, will there be harm caused to the people in Los Angeles, if, or the plaintiffs, if the stay is granted, or versus if it's not granted, right? Between the government and the plaintiffs, who's going to suffer more harm? That type of balancing act can be difficult for judges. Okay. Now look at what Justice Kavanaugh also goes ahead to say. He says, to be sure, I recognize and fully appreciate that many, not all, but many illegal immigrants come to the United States to escape poverty and the lack of freedom and opportunities in their home countries, and to make better lives for themselves and their families. And I understand that they may feel somewhat misled by the varying US approaches to immigration enforcement over the last few decades. So what he's trying to say is that, look, the fact that Biden came and you were misled into thinking you can stretch your legs and sleep comfortably in your couch, even if you are unlawfully present in the US, that time is over. You were just misled. Go on and listen. It says, but the fact remains that under laws passed by Congress and the president, they are acting illegally by remaining in the United States, at least unless Congress and the president choose some other legislative approach to legalize some or all of those individuals now illegally present in the country. And by illegally immigrating into and remaining in the country, they are not only violating the immigration laws, but also jumping in front of those non-citizens who follow the rules and wait in line to immigrate into the United States through the legal immigration process. Okay. He goes on to say the interests of illegal immigrants in evading questioning and thus evading detection of their illegal presence are not particularly substantial as a legal matter. He says it's typically brief, and so yes, it forms the basis of reasonable suspicion. Obviously, you guys know Justice Sotomayor dissented along with Justice Keegan and Justice Jackson. They said this is a violation of the Fourth Amendment. That decision is yet another grave misuse of our emergency docket. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low wage job rather than stand idly by while our constitutional freedoms are lost. I dissent. Justice Sotomayor gives a beautiful dissent, very, very, very powerful um, dissenting opinion, which is about runs about 20 pages. We don't have time to go into all that. I won't bore with you guys with all that very wonderful words that she has pinned down. Okay, now to let's move on to other discussions. So, as you guys know, based on the Supreme Court ruling, the district court order from the Central District of California is now on hold. It will not be enforced. So, ICE has freedom to now conduct these searches, stops, questioning based on these factors, along with other factors. Okay, and the case is still being appealed in the Ninth Circuit Court of Appeal. So this is just an interim order. This is just an interim order. And if you guys are following our social media platforms, I discussed why, even though ICE has been empowered in Los Angeles, they are likely going to feel that they can use these same factors throughout the United States. The decision of the Supreme Court was limited in scope, right? Because it's supposed to be for just Los Angeles. But unfortunately, it is likely not going to be limited to Los Angeles. And I'm going to show you in a minute why. I'll give you a few reasons why you're going to likely see ICE doing more of these stops throughout the country. This is another application for stay decided by the Supreme Court in July 2023, the case of Donald Trump versus Mary Boyle, where the Supreme Court stated that although our interim orders are not conclusive as to their merits, right? That application for stay was not a full merit hearing; it was an interim order, so it doesn't go into the merits of the case, but it informs how a court should exercise its equitable discretion in like cases. Okay, so now if you look at the standard that the Supreme Court uses to even grant the stay, it's quite a high threshold that they're likely going to be successful on their merit, or that if the Court of Appeals ruled in favor of the plaintiffs, the Supreme Court would grant a certiorari, meaning the Supreme Court would overturn or reverse the Court of Appeals decision if it ruled in favor of or it ruled against the Trump administration, meaning they've been able to show that the Supreme Court pretty much agrees with the Trump administration. And the Supreme Court is saying that this should inform how courts should exercise their discretion. And so even if ICE does this in New York or in Ohio or in Virginia, and people take this to court saying, oh, ICE just stopped me based on the way I speak English. A lower court is likely to look at this decision by the Supreme Court as signal to say, okay, well, the Supreme Court said that this is fine. It's reasonable suspicion, it's fine. And so the lower court is likely to rule along the same lines as the Supreme Court, because the Supreme Court is the big brother of all these courts. Okay. And again, you will see that. Let me show you how the Trump administration celebrated this. Let me see if I'll find it right here. Yes, they found this. Obviously, DHS. They said DHS caused major victory at Supreme Court. They said that this is a win for the safety of California and the rule of law. You see, all these kind of signals, they go on to talk about how Justice Kavanaugh's discussion, and they ruled in favor of the Trump administration 6-3, and they stayed a ruling by federal judge Mami Ewusi Frimpong. I'm sure that woman is now has been probably marked in their books. But yeah, now with this kind of celebration, I doubt that ICE is going to, they've been empowered, right? It says it's for Los Angeles, but really, what shows that they're going to limit it to Los Angeles? Because other courts are going to follow the lead of the Supreme Court. Supreme Court has already stated that it's an interim order, but courts should rule in this. They should follow the lead of such interim order in like cases, in cases which are similar. And so in practice, they are likely, it wasn't a merits ruling, which means that it doesn't have presidential force, right? Precedence means that it doesn't set the precedence. But even though it doesn't set the precedence, the Supreme Court has signaled a fair prospect of success on appeal for the Trump administration, which encourages ICE agents to act as if those things are lawful ground. Color of skin, you speak English with an accent, those things are reasonable suspicion. And so I foresee ICE using these factors throughout the United States because the Supreme Court has agreed that they form reasonable suspicion. Now, guys, let's move on to the Hyundai raid that happened, I believe, last week or so. 8 days ago, yeah, about a week ago. Let me take this screen off. Let me take this share thing off. Let's continue to have our discussion. Guys, you can start dropping your questions. We'll be answering questions. As usual, I want this to be a relaxed discussion so that we can all have fun and enjoy the session. Well, let me just end by saying that, the Supreme Court has different types of opinions that they give, and different types of opinions, right? So they can give some of these interim orders and sometimes full merit hearings. Okay, so this one was an interim order, and so it's very temporary. We're still waiting to see what the Ninth Circuit Court of Appeals will rule on in this case. And you better believe that Trump administration will not give up. If that judge rules against them, they will take it up to the Supreme Court, because now they know that they have, and especially in this case, they have the backing of the Supreme Court. So let's watch to see how everything goes. Let's move on to the Hyundai raid. You guys, this Hyundai raid, it's really very, very interesting, and I'm going to show you guys why. Okay, let's talk about it. Why? Okay. So according to reports, South Korean companies and subcontractors are building factories in the US. And this has been encouraged across multiple US administrations. And the goal has been to help revitalize the American manufacturing industry and to compete with China. The US wants to compete with China. It's written in a lot of their documents. They say they want to compete with China in terms of AI, in terms of manufacturing. They want to become competitive. So the US government or administrations have encouraged a lot of trade and investments from other countries, including South Korea. South Koreans are building plants. They have a Hyundai, or Americans would say Hyundai, facility in Georgia where the raid happened. And so on September 4th, ICE conducted a major raid at this Hyundai's electric vehicle manufacturing campus near Savannah, Georgia, specifically at a construction site building a battery plant. This was a joint venture between Hyundai and LG Energy Solution. And the raid they conducted was the largest single site raid that the US has ever seen. Largest single site raid. About 475 people were detained. Most were reported to be South Korean nationals. Many of the people who have been detained, they've since been released and they are back in South Korea. Okay, so Hyundai's $26 billion commitment was to build in the US. Um, there was a $26 billion commitment to build in the US. This was one of the early wins for President Trump. Um, because he was able to get some of these South Korea companies to come and invest in the United States. Now, ICE went there and they say that it was part of months-long investigation into unlawful employment practices. Apparently, ICE was looking for some Latino people. And so they went there expecting to sweep up Latinos, and then they found South Koreans. And interesting enough, apparently they didn't even have a South Korean translator. So the raid was a hot mess. You can imagine South Koreans from South Korea versus ICE officers who don't speak the South Korean language. They are trying to raid them. So obviously there would be a lack of communication where you can't even answer the questions because it's like, okay, these people are speaking South Korea, you don't understand, you just handcuff them. And it was more like just sweep everybody up and then figure out who had what later. They claimed that some people had valid authorization, B visas, B1 visas. Others did not have valid authorization to do what they had to do. Okay. Now, according to reports, some of these people did have valid B1 visas, and some of them were on ESTA. And we have discussed right here the what B visas allow. You know that viral story about the Nigerian who was coming to do business. We did it during a live session, and I showed you what the law says about. Let me share the screen here. We're going to look at what a B1 visa entails, what you can do on a B1 visa, and what you cannot do on a B1 visa. Now, let me just before we go there, let's talk about the fact that it was a Hyundai LG battery plant situation, right? Now, the workers apparently were from LG suppliers. They were not directly employed by Hyundai, and many of them were technical or engineering staff, equipment installers. They were not, this was not general labor. So these were specialized workers. And those roles are apparently very critical during construction or commissioning phase of a plant. And many of the things they were coming to install, all the parts were written in South Korea. The instructions, how to do everything, are written in South Korea. These you won't find in the US because the equipment and pieces of equipment they were using, the skills, these are all from South Korea. And some of these specialized tools, machinery, the calibration, startup procedures, expertise, those things are not yet available in the US. And so they were here to install, to train, so that US workers could start working. They were going to employ thousands and thousands of US workers. And so these were critical, specialized experts in battery plants that they needed, okay, because obviously the high precision machines, and they have the engineers and technical specialists. They know how the detailed process of cell chemistry, quality control, safety standards, unique tools, and whatnot. Now you've run them down because you claim they were on ESTA, they were on B1 visas, but B1 visas and ESTA visas allow certain types of work. It's not actual labor. Now let me go to the law for you guys to see. We're going to use the Foreign Affairs Manual, and you will see what the law allows. What the law allows people on B visas. Let's see if I have it. No, this is, oh my gosh, not this one. Let's see. Not this one as well. Let me see. I'm sorry. Hold on, guys. I had this all pulled up, but as usual, technology. Let me see if I can just pull it up from. Okay, from one other source. Let me use another source. We're going to use a Foreign Affairs Manual. That is the single most authoritative source of law for consular officers when they are going to grant you a visa. Let's see here. Okay, yeah, I'm going to one of my team members. That's fine because I cannot find the. You know what? Let me see. I think this could work. Let's see. Okay, there you go. There you go. So this is the Foreign Affairs Manual. Let's go into it. It says here, certain other business activities classifiable B1, okay, commercial or industrial workers. Well, it comes here, it says that while categories listed below generally may be classified under proper applicable non-immigrant class, A, that is A, E, H, F, L, or M visas, you may issue B1 visas to otherwise eligible applicants under the criteria provided below. Number one, an applicant coming to the United States to install, service, or repair commercial or industrial equipment or machinery purchased from a company outside the United States, or to train US workers to perform such services. However, in such cases, the contract of sale must specifically require the seller to provide such services or training, and the visa applicant must possess unique knowledge that is essential to the seller's contractual obligation to perform the services or training, and must receive no remuneration from a US source. Okay. Okay. So you see that right there. If you are coming into the US specifically to train or to you have a specialized skill, you're not coming to work, but to just install things like that. The B1 visa is a valid visa for that purpose. And remember, the ESTA is the Electronic System Travel Authorization. Some countries, over 40 countries, they have the ESTA program, meaning they're under the visa waiver program. For those countries, they are not required to apply for a visa. They just have to do the ESTA. They have 90 days to come in, and then they have 90 days to come in, and they can leave after those 90 days. Hold on, let me share this thing with you, this other portion with you. Let me share something on the ESTA, and then you guys will also see let me go back here. How do I? Okay, yeah, I can close this out, and because I'm looking for another thing that I sent here. Let me share this other thing with you. I hope I shared it here. Oh my gosh, where is it? Okay, I cannot find the other document I'm looking for on the visa waiver program. Okay, I think I have it. Okay, I think I know where I can find it. Let me pull it up. I had marked out the section of law I wanted us to use to discuss this. Okay, there you go. Bear with me, guys. So South Korea is one of the countries that is on the visa waiver program. And guys, the visa waiver program, it's specifically for countries that don't have a high level of visa overstay. So if your country has a high level of visa overstay, you will not have the visa waiver program where your people can just apply, because the ESTA application, they just go online, fill out an application, and within 15 minutes or 5 minutes, they are granted authorization. They can enter the US without a visa. And then within 90 days, they have to leave. Unlike us from other parts of the world who have to apply for a visa and wait for sometimes 1 year just to get an interview and go in for an interview. These people don't have all of that. So look here, this is the visa waiver program. Let me show you here. It says that requirements of using the visa waiver program. You must meet all the following requirements to travel to the US on the visa waiver program. Travel purpose must be permitted on a B visa. So the B is allowed, right? The B visa is what I showed you. You can come and install, service, train US workers on a B visa. You'll see South Korea is so you must be a citizen or a national of a visa waiver designated country. So as you can see, South Korea is a part of that visa waiver program, and so some of them were on S test, some of them were on B, and so it's just very unclear why but the thing is that many of the ICE officers sometimes don't even know the laws themselves. So they think that, oh, B, you're not allowed to work or do anything. Yes, you're not allowed to work in the technical sense of the word, but there are certain things that you're allowed to do. And obviously, if there was even a language or communication barrier, then they couldn't have even determined what they should do. Now, when Trump heard that, oh, these people were here to train US workers, they were here to install these things, specialized equipment, they're the only ones. And the other thing is that the companies that produce these parts in South Korea also, apparently there's intellectual property concerns. So it's not everything that they can train US workers to do. So they have to have some of their expertise or their experts come and due to intellectual property concerns, it's not everything they're going to reveal to the US workers. Now, when Trump heard that, oh, these people were, doing all these investments, they're doing something major. There's supposed to be a plant opening up in 2 or 3 months. He now said, okay, let them pause the deportation so that the South Korean experts will train US workers. And they declined. The South Koreans said, nope, no, thank you. They are so shocked, they are distraught, they are worried, and they've all flown back to, about 300 of them, I believe this morning or some hours ago, they've been flown back to South Korea. And the truth remains that US immigration is very complex. It's very unclear, too many trips and traps. And at the end of the day, it might end up biting the US in its butt or in its tail, because the US has to realize that they can continue to bully some countries, but it's not every country that can be bullied. Okay, some of the countries have a lot of foreign direct investments in the US, and so if they decide to withdraw those things, the US is going to suffer on a limping leg. And so Trump has now backtracked, and they are trying to create some type of agreement to see how they can bring those workers back. Let's see how all of that goes. There's so much to talk about. We don't have time as usual, but let me see if we have any questions. Guys, if you are enjoying the session so far, please, as usual, drop your emoji. Let me be sure you can hear me and you can see me. You are enjoying the session. And LinkedIn, Tabitha O says, do you deal with immigration fraud? What does that mean? Please contact our office and we can help you. Yes, we help immigrants who have been wrongly accused of immigration fraud, to challenge the government. We've had a lot of success. We'll review your case and we can let you know how we can assist you. But we are not the police, we are not ICE. You guys, you will not believe that people have been reporting their exes to us. Some of the emails, I look at it and I'm like, oh my goodness. I have people reporting. I'm not going to break up marriages here, but I have husbands reporting wives who have left them, giving me and my office where we can find their wives to go and arrest them because they are using fake papers or they did something wrong and they are reporting all these people to us. We're not immigration, we're not ICE. So you shouldn't be reporting your boyfriend or your ex-wife or your ex-girlfriend to us for arrest, okay? If you want to report somebody, a law office that is representing immigrants is not the proper place to do so. We don't have law enforcement powers. So, Tabitha, I'm not sure what you mean by do you deal with immigration fraud? But yeah, contact us. Let's see how we can help. But yes, we do help immigrants who have been wrongly accused by immigration for fraud, or they have a marriage fraud bar. We look at how can we help you? What are your options? What can you do? Yes, we can assist with those type of things. Our contact details are right there. So feel free. It's a really crazy time. I said people are reporting even their uncles and friends that they know are using fake papers. They are reporting them to our offices. So you guys can imagine the number of reports that ICE is getting from people. If you've broken somebody's heart and you told them about your immigration situation, that you did some type of marriage fraud, you gotta beware. You have a friend, you fallen out, you told a friend that you were using a fake social security, you gotta be aware. These people are reporting, they are reporting. So it's a lot happening. I'm seeing it more and more. I mean, in the past, we used to get some of these reports, but now there's an uptick in those reports. So that is why in immigration, your lawyer is the only one you should trust. Stop listening and telling people everything about yourself. Okay. You have an attorney, you discuss with them. Don't go to parties and be discussing your immigration situations with people or even in your bedroom. You never know. You never know. So just be aware of all that. Okay. And sometimes, honestly speaking, some of these complaints are not true. Sometimes I talk to people and I tell them, look, there's a difference between broken heart and marriage fraud. You brought your wife from Ghana, you she got a green card through you, you guys have two babies. And then you're accusing her of marriage fraud that she used you for papers. That's broken heart you have right there. It's not marriage fraud. She didn't pay you $20,000 to get her green card. You had a thing, you had a situation, and she left. You guys even have two children. So how can that be marriage fraud? Okay, so the fact that you have a broken heart or the relationship didn't work out is not marriage fraud. And sometimes immigration also gets it wrong. People just use marriage fraud, loosely, but some of the things are not marriage fraud. Okay, so that's just by the way. Let's see, we have a few questions and then we can hop off. You guys, oh, last was it okay? This was it Tuesday? Yes, Tuesday, September 9th, AK Poku Law 10, 5 years old. We're so excited. We're so humbled. We're overjoyed. And, we celebrated with all of you here on social media. Thank you so much for your well wishes, your comments. Honestly, we couldn't have done this without, first of all, God Almighty, our family support system, our team, our amazing clients, and our social media family. I'm so thankful to all of you from day one, even being here, hearing us out, commenting on our posts, tagging your people, sharing. Amazing, amazing, wonderful community. We're so thankful to all of you. So 5 years down. Okay, now if AK Poku Law was a child, at 5 years old, they would be starting kindergarten. So we're kindergartners. We're now, we're graduating, we're growing, and I've had people tell me, "What? 5 years? You guys, it's like you have 30 years of experience." And I won't lie to you, that's what I hear all the time, even from senior attorneys who have 25 years, 30 years of experience. Like, my goodness, you've made so much impact, you've done so well. And we're just really humbled. It's just by the grace of God, we are just doing our best as the little we can do, as much as we can. And we're looking forward to more years of growth with all of you. So thank you once again for all your beautiful, amazing support. Let me see if I have a couple of questions here. Nila Tilate says, hello, Lawyer AK or Lawyer Kia. I hope you're doing well. This is from Instagram. My iPhone 30 got approved in June. I've gotten an email from NBC. I'm yet to submit my DS260, but I recently moved to the UK this September. Okay, yes. So, immigrant visa, where you're going to be scheduling your interview they've released the rules. It has to be your country of residence or country of nationality. So you feel free to contact us and we can assist. Now, let me tell you, the I-130, the first part, usually your family member has to designate a consulate where you are going to be interviewed. If they don't do that, you're going to have to pay some more fees to file the I-824 notice for USCIS to take action on an approved petition for them to transfer to the or reroute your approved petition to the proper consulate. If you are in Nigeria or UK or Ghana, then they'll reroute there, and then you can attend your interview there. Please feel free to contact us so that that is properly done for you. Okay. Mimi Okoro says that my brother has a 2-year green card with a 48-month extension. He's traveling to Africa. Can he use it to travel while waiting for husband 10 years? Yeah, so you see that's a conditional green card right there. A 2-year green card. So there are 3 types of green cards. There's one type of green card with no expiration date. Those were issued a very long time ago. We've been seeing those. No expiration dates. It's like valid indefinitely. USCIS has been encouraging people. If you have that one, come and get the 10-year one. Okay, because they're phasing that one out. The second type of green card is the one that's valid for 10 years. That's a permanent green card. Then the last type is the one valid for 2 years. If you've been married to your US citizen's spouse or green card holder spouse for less than 2 years, then you get a 2-year green card. Or you did it based on investment. You've been you did it based on investment. You get the initial conditional 2-year green card, and then you file to remove the conditions. And then when you file to remove the conditions, you get a 4-year extension of that green card, a 48-month extension. And then you can remove the conditions, you get a 10-year green card. Now, all these types of green cards, they're valid indefinitely, valid for 10 years, valid for 2 years. Same rights, same responsibilities. That's the same thing. You can travel, you can work, you can file for family member, you can apply for jobs or whatever you can do with a 10-year green card, you can do with a 2-year green card. The only difference is that with the 2-year green card, you have to file to remove the conditions 90 days before the expiration. So yes, he can absolutely travel while doing what he's doing. But if you have a conditional green card and you have any type of criminal issue, I would recommend that you make sure you seek legal advice before you travel. Okay, where you can, if it's non-essential, then you can defer travel. All right, guys, it's been an amazing pleasure. Okay, Charles, let me answer this question. Charles D. Epemo says, if you already have your interview date in another country, can you still go for it? Or it's been canceled due to effective on September 6th? Okay, it looks like you're talking about the non-immigrant visa rule, the new non-immigrant visa rule from September 6th. You can only have your interview, non-immigrant visa interview in your country of nationality or where you are resident. If you already have your interview date scheduled in another country, it's not been canceled or rescheduled. It continues. Okay, so that's fine. Existing appointments are not being canceled due to the new rule. So you can just continue there. Mercy NTS on YouTube said, good afternoon. I have a question. If an asylum case is pending, if the person is intercepted by ICE or police, can you be arrested? It depends. Mercy, please contact us and let's discuss this issue. You guys know that there are asylum people who have a pending asylum who are already being arrested, and now there's new law. Those people are subject to mandatory detention. And so depending on how you also enter the US, you could also not only be arrested, but you could be detained pending the effective disposition of your case. So depends on a few things, but yes, you can certainly be arrested. Okay. All right, guys. Thanks again for joining us. Have a great rest of your day and a wonderful weekend. Bye-bye. I'll see you soon next week. Okay, I'll see you soon next week, same time, if God permits. Bye.